hard work, right tenor. Good evening, everyone. Distinguished guests on and off the dais, faculty members, my fellow students, and dear participants. I, speaker K.S. Maitri, welcome you all to the Valedictory ceremony of the 6th Surana and Surana KLE Law College National Constitutional Law Moot Court Competition 2023. Music transcends boundaries, weaving melodies that echo the essence of our collective spirit and harmony. I call Ms. Sahitya Ramesh Pujari to render the invocation song.
ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ಶರಣು ವಿದ್ಯ ಪ್ರದಾಯಕ ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ಶರಣು ವಿದ್ಯ ಪ್ರದಾಯಕ ಶರಣು ಪಾರ್ವತಿ ತನಯ ಮೂರ್ತಿ ಶರಣು ಪಾರ್ವತಿ ತನಯ ಮೂರ್ತಿ ಶರಣು ಮೂಷಿಕ ವಾಹನ ಶರಣು ಪಾರ್ವತಿ ತನಯ ಮೂರ್ತಿ ಶರಣು ಮೂಷಿಕ ವಾಹನ ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ನಿಟಿಲ ನೇತ್ರನೆ ದೇವಿ ಸುತನೆ ನಾಗಭೂಷಣ ಪ್ರಿಯನೇ ನಿಟಿಲ ನೇತ್ರನೆ ದೇವಿ ಸುತನೆ ನಾಗಭೂಷಣ ಪ್ರಿಯನೇ ಕಟಿತಟಾಂಕಿತ ಕೋಮಲಾಂಗನೆ ಕಟಿತಟಾಂಕಿತ ಕೋಮಲಾಂಗನೆ ಕರ್ಣಕುಂಡಲಧಾರನೆ ಕರ್ಣಕುಂಡಲಧಾರನೆ ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ಶರಣು ವಿದ್ಯ ಪ್ರದಾಯಕ ಪುಟ್ಟ ಮುತ್ತಿನ ಹಾರ ಪದಕನೆ ಬಾಹು ಹಸ್ತ ಚತುಷ್ಟನೆ ಪಟ್ಟ ಮುತ್ತಿನ ಹಾರ ಪದಕನೆ ಬಾಹು ಹಸ್ತ ಚತುಷ್ಟನೆ ಇಟ್ಟ ತೊಡುಗೆಯ ಹೇಮ ಕಂಕಣ ಇಟ್ಟ ತೊಡುಗೆಯ ಹೇಮ ಕಂಕಣ ಪಾಶಾಂಕುಶಧಾರನೆ ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ಶರಣು ವಿದ್ಯ ಪ್ರದಾಯಕ ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ಶರಣು ವಿದ್ಯ ಪ್ರದಾಯಕ ಶರಣು ಪಾರ್ವತಿ ತನಯ ಮೂರ್ತಿ ಶರಣು ಪಾರ್ವತಿ ತನಯ ಮೂರ್ತಿ ಶರಣು ಮೂಷಿಕ ವಾಹನ ಶರಣು ಮೂಷಿಕ ವಾಹನ ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ಶರಣು ವಿದ್ಯ ಪ್ರದಾಯಕ ಶರಣು ಸಿದ್ಧಿ ವಿನಾಯಕ ಶರಣು ವಿದ್ಯ ಪ್ರದಾಯಕ ಶರಣು ವಿದ್ಯ ಪ್ರದಾಯಕ ಶರಣು ವಿದ್ಯ ಪ್ರದಾಯಕ
Thank you, Sahitya, for the rollful rendition. I now request Dr. Anita MJ, Vice Principal, HOD PG Department, KLE Law College Bengaluru, to welcome the guests of the ceremony. Ma'am, please.
Good evening. Respected dignitaries on the dais and off the dais, members of staff, participants, and my dear students. From last 2 days, we have been witnessing intellectual feast of Surana and Surana National Moot Court Competition. I am sure that participants have immensely benefited by the intellectually stimulating exercise. Today we have gathered here for the valedictory function of Moot Court Competition. On this significant event, I am privileged to welcome guests of today's function. First, I would like to extend a very warm welcome to Chief Guest of today's function, Honorable Mr. Justice Srinivas Harish Kumar, Judge, High Court of Karnataka. Welcome, sir. I request Ms. Radha, faculty, to present a sapling to sir as a token of respect. Basavaraja, Judge, High Court of Karnataka. Welcome, sir. I request Ms. Sharmila, faculty, to present a sapling to sir. I would like to extend a very warm welcome to guest of honor of today's function, Honorable Mr. Justice Venkadesh, Judge, High Court of Karnataka. Welcome, sir. I request Mr. Praveen, faculty, to present a sapling to sir as a token of respect. Thank you, sir. I would also like to extend a very warm welcome to our beloved principal, Professor Dr. J. Mallikarjunaya, Dean Faculty of Law, KLE Technological University. Welcome, sir. Ms. Sarma, faculty, to present a sapling to sir as a token of respect. Thank you, sir. I would also like to welcome Mr. Preetham Surana, Head Academic Initiative, Surana and Surana International Autonomous. Welcome, sir. I request Mr. Tanmay, faculty, to present a sapling to sir as a token of respect. Thank you, sir. I would also like to welcome Madam Basavaraja to today's function. I request Ms. Sunita to present, faculty, to present a sapling to Madam. I would also like to extend a very warm welcome to members of staff, participants, guests, media, and my dear student. Thank you. Thank you very much.
Thank you, ma'am. We have with us three illustrious judges of the High Court of Karnataka. I call Ms. Rashmi Rajanna, Chief Examination Officer, KLE Law College Bengaluru, to introduce the chief guest and the guests of honor. Ma'am, please.
I take this opportunity to introduce to you the distinguished bench to this august gathering. Honorable Mr. Justice Srinivas Harish Kumar, born on 16th June 1963, alumnus of National College Chinagar and BMS Law College Bengaluru. Enrolled as an advocate on 11/2/1987 and joined Sri M.S. Purushottam Rao, Advocate, High Court of Karnataka. His Lordship started independent practice in 1991 at Karnataka High Court, City Civil Court and various tribunals at Bengaluru, and has also practiced at various courts at Chikkarapura and court at Gudimande in 1998, the place where His Lordship did his schooling. His Lordship was directly appointed as District and Sessions Judge in May 2002 and served as Additional District and Sessions Judge at Tumkuru and City Civil Court, Bengaluru, and Principal District and Sessions Judge at Bidar, Chitradurga, Bengaluru Rural District. His Lordship, one of the senior most judges of the High Court of Karnataka, has also served as Director, Karnataka Judicial Academy, Bengaluru. His Lordship has been appointed as a Judge of the High Court of Karnataka on 14/11/2016 and Permanent Judge on 3/11/2018. To mention a few reported cases of His Lordship of significance: criminal appeal, State versus Dr. Renuka Prasad, a case pertaining to the murder of a famous educationalist involved jurisprudential analysis of various provisions of criminal law. A case of defamation between bureaucrats, Rupa D. and Rohini Sindhu. With these brief introduction, I present before you Honorable Mr. Justice Srinivas Harish Kumar, Chief Guest today's August gathering. Honorable Mr. Justice Gurusiddhaya Basavaraja, born on 3/5/1965, a native of Mettigurke village, Hiriyur Taluk, Chitradurga district, completed his schooling and graduation in Chitradurga district. His Lordship obtained LLB degree from KLE Law College Chitradurga and Masters in Law from Kuvempu University, Shumaka. Enrolled as advocate and practiced at Chitradurga in areas of civil, criminal, revenue, motor vehicles cases, land acquisition cases under Shri C. Abdul Rahman Sessions Advocate. His Lordship was appointed as Munsif on 18/10/1993 and has served the lower judiciary for more than 19 plus years at various levels and at different geographical areas from 1993 to 2022. Judicial Magistrate First Class at Mysuru, Special District and Sessions Judge, CBI Court and Parapanagara, Bengaluru, and also concurrent charge at land acquisition cases and Special Magistrate at Bomb Blast, Dandupalya and SCST atrocities cases at Bengaluru, and has served as District Judge at several districts. His Lordship also has held position as Member Secretary, Karnataka State Legal Service Authority, and as the Chairman of District Legal Service Authority, has disposed of several cases under victim compensation scheme and has conducted several legal literacy programs in various places. His Lordship was elevated as a Judge of the High Court of Karnataka on 16/8/2022. The Department of Kannada of Culture has honoured His Lordship as per the recommendations of the Honourable High Court of Karnataka in 2008 as a consideration of Lok Adalat disposal cases and Mega Lok Adalat. To mention a few reported cases of significance by His Lordship, Parappa vs. State of Karnataka, criminal revision petition, where conviction was awarded for procedural lapses under Mines and Minerals Development and Regulation Act 1957. State of Karnataka versus Mathu Setiri Gaurav, criminal appeal, where an eliminating judgment on the practical applications of and evidentiary value and statement recorded under section 164 of CRPC was held. With this brief introduction, I present Honorable Mr. Justice Gurusiddhaya Basavaraja, guest of honor to this august gathering. Honorable Mr. Justice Venkadesh. His Lordship, a native of Madakaripura in Chitradurga district, born on 1st June 1975. Graduated law from SJM Law College, Chitradurga, and LLM from Kuvempu University, Shumaka. His Lordship enrolled as an advocate of High Court of Karnataka in 2000 and underwent a practice in civil and criminal law. His Lordship joined the State Judicial Services in 2012 as a district judge. He was the only one selected for the post out of 691 candidates in the 2011 batch recruitment process conducted by High Court of Karnataka. His Lordship has served in various posts including Registrar, Administration, High Court, Principal Secretary, Department of Law, Government of Karnataka. He was serving as a Principal District and Session Judge, Bengaluru Rural District, prior to his selection as Judge, High Court of Karnataka. His Lordship has observed speedy trial under NI Act guarantees fundamental right under Article 21. With this brief introduction, I present Honorable Mr. Justice Venkadesh Nayak T as a guest of honor to this august gathering. Now I also extend a warm welcome and introduction to the co-host of this event, Mr. Preetham Surana, Head Academic Initiative, is a multifaceted professional with over 3 decades of experience across manufacturing, international trading and consulting in leadership positions. Sir has played multiple roles as a lawyer, academician, entrepreneur, advisor and an adventurous sports enthusiast. And Sir, being the firm's academic initiative of Surana and Surana, under his leadership, he conceptualized and developed the world's first proprietary moot administrative software in 2013 for moot court administrations. He introduced the country's first ever moot in the Northeast sector. He has given lectures in academic institutions and successfully administered a number of international and national moot competitions. With this brief introduction, I present Mr. Preetham Surana, Academic Initiative Head, Surana and Surana Attorneys, to this august gathering.
Thank you, ma'am. Today is a special day for all the legal professionals and citizens of this country. As today takes us to the commemoration of the Constitution Day, observed on the 26th of November, we remember and celebrate the cornerstone of our nation's strength and unity. This day stands as a testament to the visionary ideals, values, and rights enshrined in this sacred document and we are here today discussing themes revolving around topics of AI in law, jurisprudence, and the Constitution itself. Indeed, we are blessed to have with us three distinguished sitting judges and also a group of budding lawyers from different parts of the country. I request everyone to kindly raise for the reading of the preamble. And I request Dr. Chairman Venkadesh, Dean Faculty of Law, KLE College University, and Principal KLE Law College Bengaluru, to kindly lead the audience.
Distinguished guests and all the participants, I take this unique opportunity to read please repeat the words of preamble which amounts to reading of the Constitution itself on this auspicious day. With your permission, sir, I read the preamble. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political. Liberty of thought, expression, belief, faith and worship, equality of status, and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual, and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you. Thank you very much.
Marking the celebration of 2 days filled with legal acumen, intense arguments, and exemplary advocacy, I invite Ms. Deeksha Khairwani, Student Convener, Moot Court Committee, KLE Law College Bengaluru, to present a report of the event.
The seeds of the competitions were sown during June 2023, the theme being the most relevant area of technology presently, which arguably is the greatest invention of mankind, that is artificial intelligence. My beloved mentor and teacher, Mr. Aishwarya Sharma, contributed to the genesis of the Moot proposition and wove a challenging set of facts together with the Constitution of India. Upon finalizing the direction of the proposition, we deliberated upon the aspects of deviation from the standard system of moot court competitions, where certain issues are given and the teams are expected to draft legal arguments for the same. For this particular edition of Surana Moot, we decided on allowing the teams to reflect on the philosophical and ethical dimensions involved when AI is used in criminal justice system and judicial decision making. We encourage the teams to think how all of this impacts the very fundamental principles of constitutional law and introduce jurisprudential arguments in their oral pleadings. Post incorporating the deliberations in the Moot proposition, the Moot Court Committee assembled to make preparations for this grand offline event, witnessing participation from 35 law schools all across the country. To make it an even number, a dummy team from our institute was placed. Our brilliant students, though qualifying to octafinal rounds on their own merit, were subsequently removed from the preliminary rounds. The task of organizing this huge event was daunting for all of us, but my committee members were prepared for what was coming. Whether it was Jayant and Dev, who have practically stayed up all night to facilitate accommodation, or Gargi and Srikriti, who ensured that the teams received fairest and finest of judges, or even Pratik, who guaranteed that the memorials were evaluated and scored on time. As the dates of the competition came closer, we all put pedal to the metal. The inauguration ceremony was held on 24th November, where we were fortunate to welcome Honorable Mr. Justice A.V. Chandrasekhara as the chief guest, with Professor Dr. Kushal Vibhude and Mr. P.S. Rajgopal as our guest of honor. The preliminary rounds commenced in full swing, with the contestants locking horn with their respective opponents, exhibiting their grit and professionalism in order to secure a spot in the final rounds. What began as a group of 36 teams eventually narrowed down to 16, 8, 4, and 2 after an exhilarating set of octa, quarter, semi-finals and final rounds, respectively. The smooth running of the rounds was ensured by the volunteers, who were vigorously trained by Kusuma and Madhurika. A diverse panel of judges, which included academicians, practitioners, researchers, High Court and Supreme Court advocates, were invited to adjudge the proceedings of the competition. We have again been extremely fortunate to have Honorable Mr. Justice Srinivas Harish Kumar, Honorable Mr. Justice G. Basavaraja, and Honorable Mr. Justice Venkadesh to adjudge the final rounds. All the judges have remarked about the exceptional performance of all the participants, which made it a strenuous task for them to determine the champion team for each respective round. However, behind the scenes of all this, Aditi and our General Secretary Arushi commanded the scoring committee, with Nilesh and Amrita assisting them to make certain timely results. All the faculty members and their support has been so significant for us, especially Principal Sir, Manoj Sir, Rashmi Ma'am, Soumya Ma'am, who guided us throughout the competition. Wherever we failed, they were present to pick us up. My beloved faculty convener of Moot Court Committee, Mr. Ashwin Menon, supported us every step of the way and made sure that the core committee had at least one meal at the end of the day. My dearest committee members, who have worked tirelessly and round the clock to ensure that this competition becomes a huge success. And today, 26 November, which marks the end of the 6th Surana and KLE National Constitutional Law Moot Court Competition, I, Deeksha Firwani, convener of the Moot Court Committee, can proudly say that this competition has been a huge success. Thank you so much.
Thank you, Deeksha. I now invite Honorable Mr. Justice Venkadesh Nayak, Judge, High Court of Karnataka, our guest of honor, to share a few insightful words. Please, Your Lordship.
Good evening to one and all. The KLE Law College has organized 6th National Constitutional Law Moot Court Competition on the issue of artificial intelligence on the occasion of Constitutional Day. The dignitaries present on the dais, Honorable Mr. Justice Srinivas Harish Kumar, Senior Judge, High Court of Karnataka, Honorable Mr. Justice G. Basavaraja, Judge, High Court of Karnataka, Mr. Pritam Surana, International Attorney, Professor M. Mallikarjunaya, the Principal, KLE Law College, Sri S.R. Somshekar, Retired District Judge, Judicial Officer, family members of Judges of High Court of Karnataka, other dignitaries who are present of the dais, senior faculties, all students, staff of the Law College, members of the electronic and print media, ladies and gentlemen. It is an immense pleasure to be with you, and I thank the members of the KLE Law College for inviting me in this August gathering. The law students participating in Moot Court can be both challenging and immensely rewarding. It offers a unique opportunity to develop essential legal skills, gain practical experience, and build valuable connections with the legal community. Therefore, participants in Moot Court offers several benefits, including enhanced research skill. Moot Court requires extensive legal research, helping participants become expert locating and analyzing relevant laws and precedents. Moot Court improve writing skills, crafting persuasive briefs, sharpens writing skills, ensuring participants can articulate their arguments clearly and concisely. Moot Court improves oral advocacy skills and provides a platform to practice and refine oral advocacy crucial for courtroom's success. Moot court encourage confidence building, presenting in front of judges, and appreciate building confidence, a vital attribute for any legal career. Finally, moot court ensure critical thinking. Participants learn to think critically, dissecting legal issues from multiple angles. So, all students must participate in the moot court competition to enhance legal skills and to avoid fear psychosis. Dear friends, the study of law is useful in a variety of points of view. It qualifies a man to be useful to himself, to his neighbors, and to the public. These were the words of Thomas Jefferson, which indeed explain the essence of law as a discipline and a law seeker as a leader. It is not wrong to say that pursuing law is not just a career option, but a life-changing experience for many. Law as a career brings out excellent leaders and passionate human beings to the world. This statement can be backed by personalities like Mahatma Gandhi, Barack Obama, Dr. Rajendra Prasad, and many more. The question may arise as to how to study law and to get the job. The first step in starting a career in the law in India is to pursue LLB after degree and BAL LLB after 12th class. Upon completion of the course, you can either start practicing law or join a legal firm. Another option is to prosecute LLM. What is important to note is that a career in law does not necessarily mean representing a clients in courts or tribunals, but it has a wider scope. Apart from tendering advice to the government agencies, business and individuals on legal disputes and issues, law graduates can be appointed as judges, litigators, consultant, analysts, corporate lawyers, banking and insurance panels, special officers, public prosecutors, investigators, solicitor, lecturer, professor in law, district government pleader, high court government pleader, government advocate, advocate general, special counsel, and many more. So, the scope of legal education in India is that law is financially lucrative career as well as intellectually challenging and earns handsome salary varying as per the roles as well as the company they were working with. Another question may arise you as to how to become lawyer. So, you want to become a lawyer, or perhaps you have just completed a law degree and are looking to map out your next steps. While being a lawyer takes a huge time commitment. The profession can be extremely rewarding, intellectually, financially, and socially, no matter where you are employed. From criminal justice system to environmental law, there are many fields you can delve into as a lawyer. Which one is the right for you, and how do you work your way up there? Then, how to become a lawyer? Becoming a lawyer does not happen overnight. There are 6 critical steps you must take before you are able to become a practicing lawyer in our state. Number 1, get an undergraduate degree and you must clear Bar Council examination. Enroll with Karnataka State Bar Council in Karnataka. Join the Office of Senior Advocates for better training and advice. Have a membership with Bar Association. You must regularly attend the Court of Law, and please study the latest law of the land, and you must equip with all basic procedural law. Nowadays, lawyer's career path ladder is very optimistic. Now you are prosecuting law. Some students may get afraid that what would be their next future. Right now, job prospectus for lawyers are very optimistic. The Bureau of Labor Statistics estimate 8% job growth for lawyers over the next 10 years. The majority of lawyers work in law firms, which means private practice. In law firms, both small and large, there is usually a standard progression of job titles. You all take as you work your way up in a firm. as a law student, you may work as a summer associate or a law clerk during the breaks. You can also prepare for your career as a lawyer by working as a paralegal voluntary. Once you have a law degree, you will usually start at a law firm as an associate. And outside the law firms, there are variety of places where lawyers work. Many corporations run their own legal departments, which means you would be a full-time employee of that corporation rather than a law firm. Another large area, legal practices, is public interest lawyers who work for private or non-profit organization and provide legal services to disadvantaged populations dealing with areas such as immigration and labor disputes. There are many spaces for lawyers in government positions which range from prosecutors who represent the state. Another area is standing counsel who represent parties who cannot offer their own advocate. In addition, government counsel work as lawyers in the executive and legislative branches of the government, writing and interpreting laws, writing legal reviews, and arguing civil and criminal cases for the government. So soon after enrolled as an advocate, you will get stipend of ₹2,000 per month for 2 years initially. So dear friends, you should love to engage with challenges, problems, and arguments. This way would be the right way for you because of prestige. Since ancient times, such a career has been always linked with prestige because society pay attention to impressive appearance, high salary, and legal power. Dear friends, this way would be the right way for you because of diversity. In a process of setting up a legal system, the occurrence of diversity is a sure thing. This way would be right way for you because of opportunities and growth. For the last few years, material changes have been taking place in the economy, social life, and the political institution. Such changes have proved to expand the revenue and profit of legal professionals, and you know what, it is just the beginning. This way would be the right way for you because of secure job. If you are working in the institution or for some sort of corporate, you won't have a chance to lose the job. This way would be the right way for you because of flexibility. Well, lawyers are self-governing and they have chance to make their own schedule, set their own price, and select their own clients. This way would be right way for you because of awareness of rights and duties. So, once you start your career in law, you will automatically develop an understanding of the current rights of the responsibilities. Next time, no one would be able to bother you legally. Friends, while you becoming an advocate, you must study hard, you must know all the provisions of law and the latest decision of the High Court as well as the Honorable Apex Court. Above all, you must follow the fundamental duties and provisions of Advocates Act. You must aware of the procedural laws such as Civil Procedure Code, Criminal Procedure Code, Evidence Act, and other substantial laws. I think all of you read Ramayana. The ideal in our mythology is Rama, who stood by his Swadharma even when he desired to return to the palace Ayodhya after withdrawal of Bhumi given to KLE on the basis that Prana Jaya par Vachana Jaya, it means keep the word even at the cost of the life. Though that path is very tough, the future advocates like you and the final year law students have to adapt it to bear out the oath or Pramana Vachana to be taken when you are entering the legal profession. Another instance I would quote, though Ramana was a king and covet anything or anybody and get it, went to Sita in the garb of sannyasi and did what a sannyasi should not do. Hence, Ravana had to pay a heavy price. So, our law students, when you wear the robe of advocates, you cannot but be true to it, else you meet the fate of Ravana. Let forthcoming upcoming advocates choose either the path of Rama, which leads to glory, or of Ravana, ending in destruction. I may recall another instance what Duryodhana felt when his end was about to come, that his wife Bhanumati may suffer at the hands of Pandavas as did Draupadi at his hands. But later realization comes to him that so long as Yudhishthira is at the helm, there will be no injustice. Similarly, even an enemy or opponent must feel that he would get justice at the hands of our young advocates, and that by itself it is true safeguard. Thank you for the invitation. Jai Hind, Jai Karnataka Mata.
Thank you, Your Lordship. I now invite Honorable Mr. Justice G. Basavaraja, Judge, High Court of Karnataka, to address the gathering.
Dignitaries on the dais, Justice Srinivas Harish Kumar, Senior Judge of High Court of Karnataka, my brother Judge Venkadesh, Professor Dr. J. Mallikarjunaya, Dean Faculty of Law, Dr. Manoj Kumar V. Hiremat, IQAC Coordinator, Preetham Surana, Head Academics, Surana and Surana International Attorney, Mr. Ashwin Menon, Faculty Convener, Moot Court Committee, Svikruti S. Maitri, and other senior faculty and all students gathered here, which are come from various colleges. First, I congratulate to the principal, Dr. J. M. Mallikarjunaya, and other organizers for inviting me to participate in the occasion. I am proud to participate on this valedictory function along with Justice Srinivas Harish Kumar, Senior Judge of High Court of Karnataka. For the reason that from 23/5/2023 to 13/7/2023, I was the bench partner in the division bench of the principal bench of High Court of Karnataka in the roster criminal appeals. Today I have opportunity to participate in the full bench under the leadership of Senior Judge of our High Court of Karnataka, Justice Srinivas Harish Kumar. For this, once again I congratulate the principal to accommodate this opportunity to participate in the division, in the full bench, in the moot court competition. My brother, Judge Sri Venkadesh has elaborately explained as to the importance of the moot courts. I also endorse the same. All the participants who have submitted the arguments in final hearing have submitted their arguments, and you have substantiated your arguments with the decision of Honorable Apex Court. But one thing I would like to say in this regard, that the both petitioners and respondents have not stated, have not advanced your arguments as to the fair trial pertaining to the relevant provisions of Code of Criminal Procedure 1973. Both parties, both advocates who have advanced the arguments have not put forth the important provisions of Code of Criminal Procedure Section 4, Section 211, 207, 236 and also other provisions relating to trial, and also section the valuable right of the accused, and section 313 of Code of Criminal Procedure. Both advocates have submitted their arguments as to the fair trial and quoted one Supreme Court decision that fair trial is not an absolute right. I will not accept your arguments for the reason that in the Supreme Court has not laid down any principles in this regard. That is only a obiter dicta. That is why we have to go through the relevant provisions along with the facts of the case. That decision is not a conditional precedent. In this regard, both have not properly convinced as to the fair trial is an absolute right of the accused. In view of Article 21 of the Constitution, the fair trial is an absolute right of the citizen of India. And you have to improve your knowledge in the moot court competitions in the relevant subject, that is the hypothetical subject matter, which is the constitution of Yuga Drushti. What are the rights of Yuga Drushti? How the legislatures have framed the laws regarding the powers and function of Yuga Drushti. Whether they are these act and rules are in accordance with the Constitution of India or not. Whether they are in accordance with the principles of criminal jurisprudence. That is burden of lies always on the prosecution, and also statutory presumption as to the certain provisions like 139 of Negotiable Instrument Act and section 106 of the CRPC and plea of alibi and section 165 of Evidence Act and 145 of Evidence Act. You ought to have narrate as to the principle of criminal jurisprudence first, and on what basis the legislatures have drafted the act and rules, and what about the constitutional rights of the accused. The legislatures, what are the procedures have to be followed before a constitution of this type of Yuga Drushti institutions. What is the legal sanctity of the report submitted by the institution? You have to go through the relevant provisions. For example, I would like to say that in many motor vehicle accident cases, the investigating officer has investigated the matter and submitted the charge sheet before the court, alleging that so and so has committed an offence under section 279 and 304 IPC. As the accident is occurred due to rash and negligent act on the part of the accused, and the owner is also liable to, owner and insurance company are having vicarious liability, joint and several liability. We will, the claimants will file a claim petition on the basis of the charge sheet submitted by the investigating officer. The insurance company has appointed one investigating officer, and he has submitted a report which is contrary to the contents of the charge sheet. Then you have to analyze and you have to examine the evidence of the investigating officer, whether the investigating officer is legally empowered to investigate the matter in question, whether that investigation reports will overcome the report submitted by the IO. That has to be considered. In that background, you have to study about the powers and functions of the investigating officer who is legally and statutorily empowered to investigate the matter in question. Why the IO has to investigate the matter? Why the trial has to be conducted? For example, in a murder case, A committed a murder of B. Immediately a surrender before the police, and police will file FIR. Immediately police will conduct the measure and also record the statement of eyewitnesses and submitted the charge sheet before the court stating that, and also recorded the voluntary statement of the accused stating that he has committed the offence. Why the trial is required? Why the investigation is required? That has to be considered. In view of all this, the answer is section 4 of Code of Criminal Procedure. The competent authority, who is the investigating officer, is only empowered to investigate the matter in question. No public can investigate. No private institution is authorized to investigate. In this background, you have to analyze this type of hypothetical subject matter. Then only you can submit your arguments with the procedural aspects and also the Article 20 and 21 of the Constitution of India. With these words, I conclude my speech. Once again, I congratulate the principal and other organizers who have provided an opportunity to participate in this function. And I conclude my speech.
Thank you, Your Lordship. We have with us a true legal luminary who has inspired the futures of many lawyers. And now request our chief guest, Honorable Mr. Justice Srinivas Harish Kumar, Judge High Court of Karnataka, to bless us with the valedictory remarks. Please, Your Lordship.
Good evening to all of you. My brother judges, Justice T. Basavaraja, Justice Venkadesh, the principal of this college, Sri Mallikarjunaya, Sri Pritam Surana, the faculty members of this college, and your students, ladies and gentlemen. I thank the principal and the organizers of this moot court competition for having extended an invitation to me to be the chief guest of this function, and also as one of the judges of the final round of moot court competition. Thank you once again. Firstly, I congratulate all the participants. Winning or losing is not important, but participation is important. I am told that the performance of all the participants was good. And in the final round also we saw a good participation, good presentation. So I congratulate all the participants. When we were students of law, there was no concept of moot courting. I studied in a evening college. So morning times we used to work somewhere and evening we were attending the colleges. After the introduction of this 5 years course, moot court became an integral part of the syllabus. It's good also. It has got greater advantages. It gives an insight into the functioning of the courts. The students will learn how to prepare for the brief, presentation in the court, presentation skills. He gains courage. You will also learn the protocols of the court. Courtroom atmosphere is created in the moot court. So naturally you will come to know after becoming a lawyer how you should attend the court, participate in the courts, present your cases. It also helps in developing persuasive skills. It's most important. It's one way of getting practical training while in the student days. Therefore, the moot court has a greater advantage, and all of you have made use of the same. I don't know how many of you will take the legal profession after completing your law course. What I want to impress upon you is, as a lawyer, initially for a period of 3 years at least, one must work very hard. Most essential qualities are requirements rather. Hard work, discipline, and systematic preparation. First learn the work, don't go behind the money. Your parents have an expectation that son or daughter after becoming lawyer will flourish, will make money. That's not possible. When I joined the office of my senior, he said, divide the practice period into 30. Suppose an advocate practices for 30 years. Divide it into 3 components, 10, 10, 10. First 10 years, second period, third period. He said, second period, some work, some money. Third, all money, no work. This is how the profession is. When I joined my office this year, my senior asked my father, what do you expect? How much money is to be given to your son? He said, no, don't give anything. I will look after my son. Teach him the work. Make him learn the work. If this is your attitude, definitely one will succeed in the profession. Now, being a lawyer, after enrollment, when you attend the course, always be attentive. Carry these books, CRPC, CPC, Evidence Act. must be always with you. So whenever a judge poses a question, you can't remember all the sections. Even now, if you want, I can't. Without opening the book, I can't. You must be able to open the book and give an answer. This I emphasize because unless you are thorough with the fundamentals, you cannot convince a judge. You cannot conduct your case properly, effectively. Draft the pleadings yourself. Don't depend upon your typist. You must draft the plaint, you must draft the written statement, you must draft the applications. You must also do the clerical work. In the beginning, you are asked to do only clerical work. You must arrange the papers, you must stitch, you must give pagination, you must fill the forms, process forms, wakalat forms, copy applications, all these works one needs to do. This helps you in the beginning. If you open your office, you can't employ a clerk. You must do all the work. So this training in the senior's office will help a great lot when you become independent. Then don't miss to steal the opportunity. What is the meaning of stealing the opportunity? Usually the juniors in the beginning are asked to attend the court only for taking adjournments or to take a passover. Supposing a judge is very strict, refuses to give adjournment. If you are thorough with the facts, if you are thorough with the brief, you can present. Once it so happened to me, it was a case under the Karnataka Rent Control Act. This is an example. I remember somewhere in the year 1988 or 1990s. It was a rent control case. We were appearing for the landlord for eviction case. We were appearing for the tenants. The landlord of the house had initiated action for evicting the tenant. After attending the other courts, I entered one courtroom where in our case, the landlord's evidence was being recorded. It was an examination chief. I asked the bench clerk which case was going on. He said, your case. So after the examination chief was over, next stage is cross-examination. I requested for an adjournment. The judge refused. First adjournment it was refused. So cross-examination was taken as closed. Posted for respondent's evidence. In the evening, I went to office and told the senior, sir, this is what happened. Don't worry, he said. We'll make an application next day to recall the witness. So I thought, with the permission of the senior, I carried the file home, read the entire papers. I prepared questions to be put in the cross-examination. So next hearing date, I showed the questions to my senior. Sir, I told him, I will take an adjournment, try to take an adjournment or pass over. If it is refused, please permit me to put these questions. He read over all the questions. Okay, fine, go ahead, he said. But don't say that cross-examination is completed. Tell the judge that my senior would come and complete the cross-examination. So I went there, cross-examined him, and my senior asked me to apply for the certified copy of the deposition in cross-examination. I obtained it and showed him. He went through the entire cross-examination, said you have put all the questions. It has come beautifully. You can close your side. Ultimately, we succeeded in seeing that the petition was dismissed. So this is called stealing the opportunity. Whenever senior is not there, you must be prepared to go ahead, conduct the case. This is possible only when you have read the papers. If you go to office at 10 o'clock in the morning, carry the file just to take an adjournment, and adjournment is refused, you have to get scoldings in the court. So, if you want to become a good lawyer, you must prepare for the brief, prepare the brief. That means in the absence of senior, you must be able to conduct the case. So this is possible. Conducting a court case effectively is possible when one is thorough with facts first, then the law to be applied, basic laws. Last comes application of case law. Don't cite the decisions in the beginning. That is not a good advocacy at all. First facts, then evidence, analysis of evidence. If necessary, refer to a case law, otherwise not necessary at all. Don't be under the impression that only if a judgment of the High Court or Supreme Court is cited, you will win the case. No, it's absolutely not necessary at all. I am telling this because the legal, when we were students, advocates were our teachers. Practicing advocates are our teachers. They used to share their experience in the classrooms. But now the pattern of teaching has changed. Without case law, I am told, you are not assessed as a good advocate. Yes, I don't, please excuse me, I am seeking excuses to the principal and the teaching faculty if I say that unless a ability to analyze the facts, teaching must be in such a fashion that every provision must be explained, its practical implications must be pointed out, and then case law must be referred. This is how the teaching pattern should be, in my opinion, sincere opinion. Then, a client comes to you, don't twist the facts. Ask him what has happened. He will say something. He will narrate the facts. Prepare the client on the instructions of the client. If it is a case on civil side, there is a law called Specific Relief Act, which deals with various reliefs that can be granted in a civil court. Find out from the instructions given to you what relief can be sought. I have seen in number of cases, the witness comes to the box, stands in the witness box and says something which according to him may be true. But if you read the plain or written statement, it is completely different. That means advocate has not drafted the plain or written statement on the instruction, on the basis of instructions given to him by the client. Once he said, one witness said, sir, this is what has happened actually. If the advocate has written like that, I am not responsible. Basic law is, if there is variance from pleadings, evidence is not in accordance with pleadings, that evidence has no value. Therefore, all the students who want to become advocates, don't keep the case law in your mind when you are drafting a plaint or a written statement. draft a plain or written statement on the basis of the instructions given to you by your client. Mold the relief. What he wants actually is very important. What you think is not important. What he wants is important. This is possible only when you are attentive to the instructions given to you by the. Okay, this is on the trial side. Why I am giving stress on trial side? Because the youngsters want to practice straight away in the High Court. It's a court of record. You don't learn anything if you enter the High Court. Unless you know the basics, unless you practice in the trial court, you will not learn ABCD of the profession. We all come from the trial side. I was practicing before just Somshekar, who is sitting there. He is also my family friend. I practiced before him. He was a very good judge. On the trial side, excellent. Entire judiciary now remembers S.R. Somshekar because the way he used to conduct the court proceedings, his judgments. Even now, he is an indispensable faculty in the Judicial Academy because of his rich trial experience. Therefore, if you want to shape yourself as a good lawyer, practice at least for 5 years in the trial court. Then you can choose any field, taxation, criminal, civil, labor, but foundation lies is in the trial court. So ascertainment of facts is very important. From the documents and from the instructions, you must be able to understand what relief actually the client wants, then you prepare the brief in that way, without applying, without having the decided cases in your mind. Then wherever I go, I refer to 3 essential qualities that a lawyer should possess. Lawyer means not necessarily an advocate. A judge is also a lawyer. A student is also a lawyer. Lawyer means one who is behind law for the benefit of the society, for the survival of the society, one who thinks legally. Welfare of the society is a lawyer, not necessarily an advocate. 3 essential requirements are. This is the 3 essential. I read this in an article by Justice Chandavarkar, who was a great judge of Bombay High Court, somewhere in 1900. He says, literary habit of mind, scientific habit of mind, legal habit of mind are the 3 essential qualities that a lawyer should possess. What is literary habit of mind? It's very simple. Your readings must be simple. You should not exhibit flourishes of language. One should understand. One must be careful in choice of words. What is important is what is to be told and what is not to be told. What is to be disclosed and what is not to be disclosed. This is possible one only a literary habit of mind. I don't say that one should be a Shakespeare or a Kalidas. It's good if you are Shakespeare. But language must be good. Then only at one glance the entire case can be understood. And scientific habit of mind. What is scientific habit of mind? That helps a lot while conducting especially the criminal cases. Now, in the case of murder, the charge sheet shows that there are multiple injuries on the entire body. Lacerations, contusions, abrasions, incised wounds. It's medical jurisprudence. But the weapon produced before the court is, say, all the injuries are lacerations. Is a club. The first thing that must strike your mind is whether the injuries mentioned in the post-mortem report and the evidence given by the doctor, what the doctor says in the court, are possible to happen if this weapon is used. Inside wounds, there must be a sharp-edged object. Contusions, a blunt weapon must be there. If you compare the PM report with the weapon produced before you, if you have a scientific thinking of mind, it is very easy to come to a conclusion. There is something lacking in the prosecution case. Either this weapon should not have been used. That means a false case must have been projected by the prosecution, or the entire case of the prosecution must be a false one. Don't think that police always file a charge sheet. There are many instances where we are seeing innocent persons are fixed. That's why a concept of fair trial. If innocent is sent to gallows, it doesn't meet the ends of justice. It is nothing but end of justice. This scientific habit of mind helps take proper conclusions, arrive at proper conclusions while deciding a case or arguing a case, a criminal case. Even in motor vehicles, claim cases, compensation is sought for functional disability because of the damage caused to an organ. 100% disability is there. If you have notes little bit of anatomy, which is the organ impaired due to accident? Is it possible to say that there is 100% disability? So this does not require too much of thinking. A little bit of scientific thinking helps you a lot in presenting the case and also as a judge to write good judgments. Most important is legal habit of mind. I even take an instance. Abraham Lincoln was a great lawyer. He often used to come across the word demonstrate. Demonstrate, everybody knows the dictionary meaning of the word demonstrate. But he thought there must be something that the word demonstrate does not, I should not go by the dictionary meaning. There must be some other meaning to it. So he referred dictionaries, legal dictionaries, all types of dictionaries. He was not satisfied. He worked day and night to understand the meaning of the word demonstrate. He said to himself, I quote, Lincoln, you can never make a lawyer if you do not know what demonstrate means. So to understand the meaning of the simple word demonstrate, he worked day and night. And this is called legal habit of mind. So Justice Chandavarkar says legal habit of mind means product of habit of analysis and abstraction. So a good lawyer possesses this kind of habit. Our seniors had this. My first senior was one Mr. Venkadesh. Once he asked me to draft an application under one provision of Civil Procedure Code. I wrote the application. Then he started putting questions on all the rules of a particular order, or 13. Or 13 rule 5 is removed. That was an application for production of document at a belated stage during proceedings. He started putting questions from rule 1. What is rule 1? What is rule 2? What is rule 3? And he said at the end, don't think otherwise. When you draft an application, you must read the entire order. Then only you will be able to understand the entire scope of that particular order, provision in the Civil Procedure Code. So this is somewhat akin to a legal habit of mind. Then coming to Evidence Act, if you put question what is Evidence Act, what does it contain? It's nothing but a codified common sense. That is a common answer we get. So everybody thinks my common sense is good. I did not understand the scope of all the provisions of the Evidence Act. It's not like that. Chandavarkar says legal is common sense means not common sense of an individual, common sense of ages of many wise people which has stood the test of time. This is common sense. That's why even now Evidence Act cannot be amended at all. But while teaching Evidence Act, the teachers can give live examples instead of referring to a decision. When you describe what is a fact, what I am doing now, I am speaking, it's a fact. If I say something, when I go out, somebody says, sir, you have spoken like this. I dispute. No, I have not said like that. It becomes a facting issue. So fact means things capable of perception with sensory organs. In Sanskrit, Indriya Artha Sannikarshak Jnana. Indriya means what? 5 sensory organs. Perceivable to 5 sensory organs is fact. Are you taught in this way? No, I am sure you are. This is how you must understand every section of the Evidence Act. When you master Evidence Act, it is very easy to conduct trial, both on civil side and criminal side. So, my dear students, give importance to all these aspects. The reason why I am taking all these, stressing all these points is to see that each one of you should become a good lawyer. Our society wants good lawyers now. Though hundreds of lawyers are getting enrolled every week, all do not flourish. Only a few will come up. If you want to come up, you must be ready to undergo all these ordeals in the beginning. Today is a Constitution Day, so something about Constitution. What I find is, there has developed a kind of obsession in quoting the constitutional provisions. Of late, 20 years, when we were students, this trend was not there. Today, you watch the media, read a newspaper, constitutional rights, flourishes of language. When I read that this constitutional right first time, it took some time for me to understand what actually the constitution writes. Everybody has understood the fundamental rights of the constitutional rights. I don't think so. Supreme Court says, if I say you may not believe, Supreme Court has said, fundamental rights are not boon from the Constitution. Constitution has not conferred the fundamental rights. It has guaranteed. What is the meaning of the word guaranteed? The rights which were there earlier will remain to exist. Nobody can snatch. Without these rights, there is no meaning to the the life of a human being on this earth. What was the position before we adopted the constitution? Whether these rights were not there? Fraternity, just now we read the preamble. Don't you find this concept in our Indian philosophy? Ayam nija paroveti ganana laghuchetasam udara charitanam vasudhaiva kutumbakam. This is not fraternity. I will give the meaning. Ayam nija paroveti ganana laghuchetasam. Laghuchetasam means one who thinks narrowly. Narrow person says, this is mine, this is yours. I am nija paroveti ganana means he classifies, this is yours, this is mine. You are different, I am different. Udara charitana tu. But one who thinks broadly says, Vasudhaiva kutumbakam. Vasudha means earth, entire world is one family. This concept was there. Unfortunately, while interpreting the constitution, these concepts are being forgotten. We can't understand the constitution without understanding the culture, tradition of this great country. We are separating the constitution from the nation. My father was a teacher. He was a teacher of Social also. When he was teaching the social studies, we had a subject called civics at that time. He said, Constitution is for the nation. Nation is not for the Constitution. Without a nation, there cannot exist Constitution. If not this Constitution, we can adopt another Constitution. Our neighboring countries have adopted. That means Constitution is necessary in a democratic setup government for the governance of this country. It's nothing but a code containing administrative guidelines. There don't discriminate from person to person. Even more than freedom of expression, everything. These rights were there. They are called natural rights. Then you may put a question, is there not a constitution? It is there. What is that? The right to give to a minority. It was not there earlier. Adult franchise. Article 14, 19, they are not constitutional rights. And everybody says what we have done is constitutional. Look at the happenings, the political developments for the last 5 years. One party comes to power. The other party indulges in large-scale defection. Is it constitutional? They take both in the name of constitution. What they have done is constitutional. Then why should I use the word constitution for everything? This is all you must understand. Without understanding nation, you can't understand the constitution. Ambedkar said, howsoever a constitution good, if the people work it is bad, it turns out to be bad. Howsoever a constitution bad, people who work on is good, it turns out to be a good constitution. We are what we think of the present day situation. So there is no meaning being more obsessed with the constitutional provisions. Try to understand the spirit of the constitution. Try to see that the sovereignty, unity, integrity of this nation is protected. Any interpretation against the country, the interest of the country is unconstitutional. So with this, before I conclude, today's moot court problem was really good. But the students who presented, their performance was good, but without, when you come to the question of fair trial, as my brother said, without understanding the provisions relating to procedure, any amount of argument based on decisions is no good. Understand the provisions. Fair trial means registration of FIR under 154 CRPC, investigation, presentation of charge sheet under 173 final report, then framing a charge. Before that, providing the charge sheet materials to the accused to enable him to seek a discharge. He can say, there are no materials to frame charge against me, drop me from trial, that right is available. Then framing of charge. Now today's moot court problem, section 111, subsection 7, previous conviction. At what stage? A charge must be specifically framed, but it must be read at the end after conclusion of trial, not in the beginning. Then trial, section 273 says, all the trial must be held in the presence of the accused. 309, day-to-day trial. 313, incriminating materials must be explained. Then after conviction, here are sentence. For what purpose? Determining the quantum of the punishment to be imposed. Even at that time, there is a separate enactment called Probation of Offenders Act that can be applied. Instead of imposing a sentence of imprisonment, he may be released on probation for his good behavior. These are all the concepts of fair trial. You must understand this and then present the case. It would have been more effective. So with this, I conclude. Thank you all.
Faculty of Law, KLE Technological University, and Principal, KLE Law College Bengaluru, render the presidential votes. Please.
Honorable Mr. Justice, Sri Venkadesh, Justice D. Basavaraja, Justice Venkadesh co-host Pritam Sarana, all the distinguished guests of the dais. It's an opportunity unique to come second time to the dais in a same program. I understand the importance of time and the paucity of time to do the rest of the honors. We are all waiting for the exciting moment of announcement of prizes. I congratulate all the participants who are indeed the winners. I wouldn't stand before you and your trophies anymore, and wish you all the best, and let's look forward for the 7th Surana and KLE Constitutional Law.
Coordinator, KLE Law College Bengaluru, for announcing the distribution of the certificates of participation.
Good evening, all. Respected dignitaries, authorities, doctors, dear participants, my dear students and colleagues. The fact that 36 teams participated in 6 Surana and Surana KLE Law College Bengaluru indicates that each team has put in effort to get selected in their college to represent that college in this prestigious competition. So hence, each participating team deserves to be appreciated, and a big round of applause to all the participants. I request the participating teams to come and collect the participation certificate as and when your name is called, and also the memento from the organizers. May I request our Principal and Dean Faculty of Law, Dr. J. Mallikarjunaya sir, to present participation certificates and mementos. And after this, the major prizes will be distributed by the honorable dignitaries. I request our Principal Dr. J. Mallikarjunaya sir to present the certificates. I call upon CNL 15 KSLU, Karnataka University's Sir Siddhappa KLE Law College, Dharwad, participants to Faculty of Law, the Maharaja Sayaji Law University of Baroda, Gujarat. CNL 02, ES Navalmal Pirodia Law College, Pune, Maharashtra. CNL 7, Savita School of Law, Chennai, Tamil Nadu. CNL 22, University Institute of Legal Studies, Punjab University. CNL 36, University Law College and Department of Studies in Law, Bangalore University, Bengaluru. CNL 27, National Law University and Judicial Academy, Assam. CNL 35, IFIM School of Law, Bengaluru. CNL 25, Ramaya College of Law, Bengaluru. CNL 30, Maharashtra National Law University, Nagpur. CNL 29, Reva University School of Legal Studies, Bengaluru. CNL 4, Symbiosis School of Law, Pune. CNL 24, Sastra deemed to be University, Tanjavur, Tamil Nadu. CNL 21, Dr. Ambedkar Government Law College, Puducherry. CNL 21. CNL 32, KLE Law College, Chikota. CNL 17, Army Institute of Law, Mohali. Thank you, sir. May I request Preetham Surana sir to present the distribution certificates to the following teams. Christu Jayanti College of Law, Bengaluru, CNL 26. CNL 31, Tamil Nadu National Law University, Tamil Nadu. Senior 16, KLE Law College, Kerala. Senior 34, Faculty of Law, PS University, Bengaluru. Senior 1, BMS College of Law, Bengaluru. Senior 18, CSI College for Legal Studies, Kottayam, Kerala. Senior 10, Vishweshwarapura College of Law, Bengaluru. Senior 20, National Law University, Odisha. Senior 20, National Law University, Odisha. Senior 19, School of Excellence in Law, Tamil Nadu, Dr. Ambedkar Law University. Senior 19. Senior 5, Christ Improved University, Pune, Lavasa campus. Senior 23, Dr. Ambedkar Government Law College. Senior 08, School of Law, Vellore Institute of Technology, Chennai.
ಫುಲ್ ಫ್ರೇಮ್ ಇಟ್ಬಿಟ್ಟಾರೆ ಮಹಾರಾಷ್ಟ್ರದಿಂದ ಹಿಡಿದು ಪ್ರಶಂಸರನಾದರು.
Senior 28, Alliance School of Law, Bengaluru. Senior 13, Ramaya Institute of Legal Studies, Bengaluru. Senior 11, School of Law, Presidency University, Bengaluru. Senior 11. Presidency University, Bengaluru. Senior 6, KLE College of Law, Navi Mumbai, Maharashtra. Senior 14, School of Law, University of Petroleum and Energy Studies, Dehradun, Uttarakhand. Senior 3, Symbiosis Law School, Noida. Senior 3. Noida, Symbiosis Law School, Noida. Senior 3. The last one, the host team, KLE Law College, Bengaluru.
The host team did participate in the competition as a dummy team, since at the last moment one of the teams had dropped out. So they came in as a dummy team, as a filler, non-participant, and they did qualify for the final rounds, and that's why the students of this college are cheering.
We have now arrived at the most awaited part of the competition, the results. I request Mr. Preetham Surana, Head of Academic Initiative Surana and Surana International Attorneys, to kindly announce the results.
Very good evening. Before I announce the results, I would like to convey my cordial compliments to the dignitaries on the dais, Honorable Mr. Justice Srinivasa Harish Kumar, Honorable Mr. Justice G. Basavaraja, Honorable Mr. Justice Mr. Venkadesh, and Professor Dr. A.M. Malik, Dean and Principal of this law college. Off the dais, Dr. Anita, Vice Principal of this law college, Dr. Manoj Kumar Hiramad, the learned faculty members of this institution, the moot court committee conveners and committee members, student volunteers, students of this law college, the staff of this law college, who have been the backbone support of this event, which has been going on for 3 days, and last but not least, the participants. My compliments to all of you. Without much ado, without anything else to add, I'll just jump to the results, announcement of results. For the results, I would request Honorable Mr. Justice Venkadesh Naik, Lordship, to do the honors and give away the following prizes. First is the 4th Best Memorial. The 4th Best Memorial goes to Sudiksha Reddy Patil, Teresa Panjikaran, and Sastika Agarwal from CNL 04 Symbiosis Law School, Pune. It seems the team is not here. The next, excuse me with the pronunciation of some of the names, maybe I don't get it right, but you will get the message. 3rd Best Memorial goes to Akshat Bhatt, Amok Shetty, Aditi Shah from ES Inauguration Law College Pune with team code CNL02. Congratulations. Continuing with the team category, we move on to team placed 4th. This goes to CNL 26, Vishnu Jayanti College of Law, Bengaluru, Varun Raj, Giridhar, David Mami Thomas, and Shubhashri Henry. Congratulations for having the team placed 4th award. now for team placed third, Swasti Jain, Mandar Lakpati, and Tanushri Patil from Maharashtra National Law University, Nagpur, CNL 30. Seems this team has some supporters in the audience. We've moved to an award in the individual category, which is based on the preliminary rounds. The fourth best student advocate goes to Arya Anushri of CNL 24, Shastra Deepak University. Thank you, Lordship, for doing the honors. I would now request Honorable Mr. Justice G. Basavaraja, Lordship, to do the honors. We continuing with the individual awards. In the student advocate category, the third best student advocate goes to CNL 25 Ramaya College of Law, Bengaluru, Apeksha. Second best student advocate goes to Samintanjay Sharma from University Institute of Legal Studies, Punjab University, Chandigarh. CNL 22. Going back to the Memorial Awards, top two Memorial Awards. Second best memorial goes to CNL 10, Vishweshwarapura College of Law, Bengaluru, Divya and Neelamika. Divya and Neelamika, it seems the team is not here. Probably they didn't expect it. Anyway, the best memorial. That's why I said the other day that confidence building is very, very important. The best memorial goes to Varun Raj Giridhar, David Marvin Thomas, of Crystal Valley College, CNL 36. Let's take from Valley for the best memorial. They get a Christmas trophy too. Thank you, Lordship, for doing the honors. Thank you very much. Now, I would request Lordship, Mr. Justice Srinivas to do the honors, continuing with the individual award. based on the preliminary rounds, beg your pardon. This goes to the best student advocate. This goes to Kushi Saxena from University Institute of Legal Studies, Punjab University, Chandigarh, CLL 22. She gets a Christian trophy. Kushi Saxena getting a Christian trophy from Dr. Mr. Venkadesh. And now, the real big one. We had two teams compete. Shastra deemed to be University Tanjavur with University College, Law College and Department of Studies in Law, Bangalore University. These were the two finalists, and the 20,000 cash prize with a trophy goes to Arya Anushri, Jenita Darshini, Shastra University, I hope I was heard. It's your day. Well, now, for the runner trophy, I invite Dhruva Goda and Vinita to come up and receive the trophy in cash prize of the University Law College and Department of Studies in Law. Now, for the biggest individual prize in this competition, the best speaker of finance. This goes to Jenita Darshini of Shastra deemed to be University. One more announcement to make before we draw the curtains on the prizes. And this is something I spoke about earlier too. That is the spirit of Surana Award. I think most of the students, participating students at least would be out. But for the benefit of all those who were not there at that time, this award was brought in since being the pioneer of moot courts in India. We wanted to lay down higher standards in mooting endeavor which has the outcome in the form of the Spirit of Surana Award, which personifies excellence of intellect and astuteness in argumentation, spirited and healthy competition, team solidarity, and a team which participates in the spirit of goodwill and harmony. We had invited the participants to come and vote, so this is based on the participation votes, and the maximum votes we received. Of course, we didn't receive all the entries, but with whatever entries we received, it was decided that the team who possesses or is close to these qualities is the team CNL 24 Shastra deemed to be university. Arya Anushri, Jenika Dakshini and Damodar Narayan once again on the stage. I think on a lighter note, with the permission of the dignitaries in the presence, this team has done great injustice to the others. So the results are over, and it's obligatory for me as the organizer, co-organizer along with KLE to thank the dignitaries on the dais for sparing the valuable Sunday time, family time, which is the only day probably most of the lordships get only half a day even on Sunday to spend some time with the family with the amount of documents even in their home office. So my cordial compliments and great appreciations for your presence here, sir. This competition would not have been possible. This I am saying as a representative of Surana and Surana International Attorneys. The host KLE Law College, headed by Professor Dr. J. Mallikarjunaya, the Dean and Principal, Dr. Anita, Vice Principal, faculty members who have put in so much of effort, especially during the last 10 days, the student conveners, the student committee members, all the student volunteers of this law school, the staff. We've been enjoying a lot of hospitality. There are a lot of things going in the background which we don't see in the front, but they are being tirelessly working to organize this event. To all the staff members here, to the judges who came in and judged the preliminary rounds, the octa-final rounds, the quarterfinals, the semi-final rounds, sparing their valuable professional time and personal time for coming and judging here. The convocation was also drafted by the faculty members here at KLE. A round of applause for giving us wonderful which is forward-looking. This is an emerging area of law. Future, this is yet to really evolve. There is no law actually, practically speaking. So this will take its form as and when artificial intelligence and all these data privacy, machine learning, these are very new emergent areas, and it's going to be really challenging. This is just the beginning of the journey. As organizers of the Surana and Surana Technology Law Moot Court, which we have been doing for the last 20 years, I know how technology has evolved and taken space from seeing typewriters, manual typewriters, to electronic typewriters, to computers, and now we are here. So, long way to go, and the law is yet to form and evolve. I would like to acknowledge the presence of Mr. Somashekar and Mrs. Basavaraja here, who have taken the time to be here with us. Thank you so much for your presence and guiding us and supporting us. To all of you present here, my good wishes. Vande Mataram, Jai Hind.
Thank you, sir, and congratulations to all the winners. I now request Assistant Professor Mr. Ashwin Manan B, Faculty Convener, Moot Court Committee, KLE Law College Bengaluru, to render the oath of thanks.
Good evening to all present. Respected dignitaries on and off the dais, colleagues, cherished participants and my dear students. I stand before you today as the faculty convener of the Moot Court Committee and a member of KLE Law College with a heart full of gratitude and a profound sense of joy as we come to the closure of this remarkable 6th Surana and Surana and KLE National Constitutional Law Moot Court competition. The past 3 days were the result of months of continuous hard work by multiple stakeholders, and I consider it my duty to thank them today from this stage. First and foremost, our sincere appreciation and profound gratitude goes to our distinguished guests. I am immensely thankful to Honorable Mr. Justice Srinivas Harish Kumar, Judge, High Court of Karnataka. Thank you, Your Lordship. I now request Dr. Venkadesh, Principal, KLE Law College, Navi Mumbai, to present a memento as a token of our respect and appreciation to His Lordship. I extend my heartfelt thanks to Honorable Mr. Justice G. Basavaraja, Judge, High Court of Karnataka. Thank you, Your Lordship. I now request Dr. Vishnu Prasad, Associate Professor of Law, KLE Law College Bengaluru, to present His Lordship with a memento as a token of our respect and appreciation. I extend my sincerest gratitude to Honorable Mr. Justice Venkadesh, Judge, High Court of Karnataka. Thank you, Your Lordship. I now call upon Mr. Venkadesh, Assistant Professor of Law and member of the Moot Court Committee, to present His Lordship with a memento as a token of our respect and appreciation. We are grateful to all the 3 judges for they took out the time for us and shed light on the path that these young lawyers must follow. A special note of thanks to our esteemed judges for the preliminary, octa, and quarterfinals and semi-final rounds, and also for the memorial evaluators who have helped us build the event to this stage, since this fierce competition is a testimony of their fair judgment. The organizing committee has not left any stone unturned. Vice Principal Dr. Anita NJ, IQAC Coordinator Dr. Manoj Kumar V. Hiremath, Ms. Rashmi R, Dr. Madhusudan, Dr. Mahesh, Ms. Soumya, Ms. Sharada, Dr. Sunita, Mr. Tanmay, Ms. Sharmila, and other faculty members have played pivotal roles in the organization of this event. I would like to extend my sincerest gratitude to all of them. I would like to mention and extend my gratitude for the dedication and contribution of Mr. Anirudh Venkadesh and other Moot Court Committee members. Thank you all. My deepest gratitude reaches out to our co-host, Mr. Preetham Surana, Head Academic Initiatives, Surana and Surana International Attorneys, and his entire team. I now request Ms. Deepa H, Assistant Professor of Management, KLE Law College Bengaluru, to present Mr. Surana with the token of our appreciation. Thank you, sir. The smooth coordination and symphony between the teams was what resulted in the 3 days being a highly educational experience, and for that, many thanks. A heartfelt thanks also goes out to the participants and attendees. Your enthusiasm and active participation have added vibrancy and energy to this moot court competition. It is your engagement that has made this event a memorable and an enriching experience for everyone involved. We as teachers are proud to witness that so bright is the future of our country, and we host such brilliant lawyers. Thank you. We'd also like to express our gratitude to the venue staff, technicians, hospitality management department, and all those behind the scenes who have worked tirelessly to ensure the smooth execution of this event. Your professionalism and attention to detail have not gone unnoticed, and we appreciate your contribution to making this event seamless. Thank you. To our dedicated team of volunteers and committee members, your tireless efforts and meticulous planning have been the backbone of this event. It is your passion and hard work that have made this day possible. Thank you. To the committee members, each one of you, namely Diksha Perwani, Arushi Srivastava, Aditi S. Govind, Jayanti Himachala, Gargi Srivastava, Swikriti S. Maitri, Anvita Tyagraj, Nilesh Nandan, Dev Bhattacharya, and Pratik Hiremati. All of you have played a crucial role. We are immensely grateful for your patience. Last but not the least, my thanks to the ever-standing pillar of our strength, Dr. J.M. Mallikarjunaya, Dean KLE Law College Bengaluru, without whose guidance and vision this event would not have materialized. Thank you, sir. I congratulate all the winners and participants for their efforts. Once again, thank you all for being a part of this extraordinary event. Your presence has been truly special. Thank you all. Until next time.
I call upon Mr. Preetham Surana, Head of Academic Initiatives, Surana and Surana International Enterprise.
There's something which is unfinished, so I just came back to complete it. I don't have a flight now, I have it in the morning, so I have enough time to complete something which is unfinished. Can you please get that? I would request Dr. Mallikarjuna and a few of his co-team members to please come on the dais. This is an appreciation from our law firm, Surana and Surana International Attorneys, to the host law school, KLE School of Law. Small appreciation of
Harry, I start this one.